Nobody will never know why it was his will for this to happen.
He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
at the end of the day,
Let him finish.
If we gonna open it up, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the top.
Did you know she said she was 18 when I met her? Did you know that?
I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't
the
have.
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
I believe you're choosing not to answer them.
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir,
this
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling you,
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
So what other details do you not recall?
Objection. Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained as to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recalling.
Objection.
Don't.
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness.
We're talking about me, though.
I understand that, sir, but
I'm going to inform them of the
your
truth.
conduct right now is delaying
I'm not attempting
The court's
to delay
intention
anything.
of moving
I let
forward
you,
with the
Your Honor.
closing argument.
I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective, that is in an attempt
How am I being dishonored?
to simply
How am I being
delay
in
what we're
dishonor?
doing.
How am
So
I being
you are
in
put
dishonor?
on notice. I am done dealing with
How am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I not
going
preserved
to
my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments.
Apparently
but
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir, and
or I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say. But I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is
not-
a whole new day. I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any
I don't
more
think I have
legal
to- I don't
advice
think I have
further
to-
than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out. And you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.